Hello YouTube. Today is October 9th, 2016. This is the Truth About Gun Laws, Part 2 of 2. Again, I'm offering a 5,000 Federal Reserve Note challenge for anyone who substantially disproves my assertions or provides critical feedback that's substantially contrary to what's presented here. In Part 1, we proved that gun laws do not infringe upon the right of the people to keep and bear arms. We also proved that your gun license or your license to carry is a commercial contract. In Part 2, we're going to prove that gun laws are acts authorizing commercial contracts with corporations, and we are going to show that gun laws are not law. Let's begin with some definitions. When used here, the word law used alone means the common law. It is the general and permanent rules of conduct within a society, the violation of which is subject to punishment. General is distinguished from special, and it's distinguished also from the rules and regulations which are limited to parties in commerce or in private societies. So gun laws mean the firearms statutes of the several states. Let's also define the parties. You have a license to carry. That is a commercial contract between you and the state. If you're charged with a victimless firearms violation, such as possession or carry, it would be the case of the state versus you. So let's talk first about the state. Who or what is the state? I refer you to Texas versus White, which is a Supreme Court decision defining the word state describes a people or community inhabiting the same territorial region, and also the term state expresses the combined idea of people, territory, and government occupying a territory. The word is a fixed and real thing, whereas the term is a specialized meaning defined within a particular field or profession. Term may be artificial, or in this case, it is considered an idea. So the definition of state parallels the definition of government, which is found in Black's Law Dictionary, as the sovereign or supreme power in a state or nation, or the machinery by which the sovereign power in the state expresses its will and exercises its functions. Therefore, in law, there is always one thing which is real and the other which is artificial. In the real state government, we have people or community, whereas in the artificial state government, we have the combined idea of the people. In a real government, we have sovereigns, and in the artificial government, we have the machinery by which the sovereigns operate. In the real state government, we have a republican form of government, and in the artificial state government, it is run by a corporation, which is the machinery of the republican government. Now, up to now, everything works well. But in 1913, the Federal Reserve Act was passed, and we started receiving or using Federal Reserve notes. The state government was still using gold and silver, but in 20 years, in 1933, the United States was bankrupt because we basically spent all our gold and silver. So when all the gold and silver were gone, the only thing that was left were Federal Reserve notes. Federal Reserve notes are negotiable instruments. That means they're IOUs, they're debt instruments. In fact, the word note means promissory note, which means absolute promise to pay. Therefore, in 1938, the laws had to change. The laws changed by the combination or the union of the law of the land or common law and civil law with equity and also admiralty law. The reason that had to change was because equity and admiralty law are the branches of law that deals with negotiable instruments. And since the United States only had negotiable instruments, we had to change from the law of the land in the real state government to equity and admiralty, which are artificial constructions, which are the color of law. Okay. Now, before disconnecting from gold and silver, the government experienced limited growth based on the amount of available currency and based on the population. But when we turn to Federal Reserve notes, which can be printed from thin air, there is infinite inflation, which leads to an infinite expansion of the administrative or the artificial state government. So, whereas once we had law enforcement, today we have a policy state. Hopefully, there is an awakening, and we would like to change that trend. Anyway, now that we have characterized the nature of the state, let us study its role in the case of state versus you. Now, we've defined that this is a victimless act, that you bearing arms or even carrying a firearm. So, if there is no injured party, there's no people. There's no real party of interest. Therefore, the district attorney has no one to be an advocate for, and the state has no one to be an agent for. Therefore, there's no standing and there's no claim, and state is not a thing. And therefore, the state, being a victimless state, can only be an idea. So, what kind of idea is the state? The state is a juristic or artificial person, it's a corporation. So, are you telling me my state is a corporation? That's exactly what I'm telling you. And if you don't believe me, you can look them up. Who has compiled the most comprehensive and accurate repository of business data on the planet since 1841? Dun and Bradstreet, of course. So you go to their website and you can search their database. You can put in your town's name, your own town, your hometown, and put it under the company field, put it under the city and the state, and do a search. For example, I searched for the Commonwealth of Massachusetts. And let me draw your attention to this report in which it says the Commonwealth of Massachusetts, that's the name of the company. It's headquartered at 1 Ashburton Place in Boston, Massachusetts. And let's see the company profile, which is right here. The chief executive officer is Duval Patrick, governor at the time of this report. And the type of business is a corporation in the line of business of executive offices. Been in business 227 years and has about 60,000 employees. So not only is your state government a corporation, but all governments are corporations. The United States government is a corporation. The United States Department of Defense is a corporation. Department of Treasury is a corporation. And all the alphabet soup agencies of the government, such as the DOJ, the HUD, the VA, the TSA, the FAA, the EPA, the NSA, the NASA, NOAA, FEMA, SEC, FDA, NIH, CDC, FBI. You get the idea. So not only are federal agencies corporations, but like I said, all the states and all the major cities, and even the small cities, probably your city, is a corporation. Not only are the states and cities corporations, but the court systems are also corporations. For instance, we have here the judicial courts of the state of Nevada, the judicial courts of the state of Colorado, and you can search them for all 50 states. In addition, the attorney general of your state is a corporation. So here we have Attorney General of Massachusetts, Attorney General of Arkansas. Again, these are randomly selected, but you can do your own search. And the governor's office is a corporation, same as the legislative branches of government, Georgia and Oklahoma legislatures, and the corrections department, the state police, and the state prisons. So are international organizations such as the United Nations Children's Fund. In fact, the United States Congress is a corporation, as is the United States Supreme Court. So we are trained in school to believe that the legislature makes law. But what we're not taught is that the legislature are legislative corporations. I have 5 pages here, each containing 10 uh, state legislatures that are all corporations. So there are 50 states with 50 legislatures, all of which are corporations. And I'll finger through those right now. Okay, so we're not taught in school. That's really the bottom line. Because the legislature is a corporation, and that statutes, including gun laws, are creations of the corporation. So, what are statutes? Statutes are corporate creations which authorize contracts, which we'll prove. They are limited to officers, employees, and contractors, and they are limited by subject matter to regulable entitlements. Now, these three statements right here give the authority, the personal, and the subject matter jurisdiction as it applies to statutes or laws in general. So, if corporations can only create enactments limited to regulable entitlements for itself and its contractors, then who makes the law? Well, I'd like to introduce you to a word that over the last 200 years has fallen in popularity in its use, and that word is sovereign. Sovereign is the one that makes law. And the reason that it's impossible to study the law without knowing this word is because sovereignty means that the decree of the sovereign makes law. And sovereignty is the author and the source of the law. Sovereignty is also exempt from suit because there can be no legal right against the authority that makes the law on which the right depends. Sovereignty is, the dictionary definition is that it's the supreme, absolute, and uncontrollable power, the paramount control of the Constitution and the frame of government. So there are two sides to the same sovereign coin, and that is there's sovereign power and there's sovereign immunity. They're the same thing. If you don't have immunity, then you don't have sovereign power. On the other hand, if someone is suing you and you claim immunity, then you can make the law using your sovereign power and make yourself immune. So immunity and power are one and the same. So let's talk about sovereignty and immunity. At 28 U.S.C. 1346, the United States can be sued for claims founded upon the Constitution or any act of Congress or any regulation of an executive department or upon any expressed or implied contract with the United States. That is to say, sovereign immunity is waived when government violates its own constitution because the people are sovereign, or it is party to a contract. So this also applies to states. For instance, in the Georgia state constitution, we have that states' defense of sovereign immunity is waived as to any action ex contract to for the breach of any contract. Okay, so when governments act through contract, they lose their sovereignty. If they're if government makes law, okay, so anyway, sovereignty makes law and it is immune from suit. If it's not immune, then it's not sovereign. And if it's not sovereign, then it cannot make law. And another way to understand it is simple. If you're not sovereign and you make a law, then the next sovereign who comes by can just overrule your law and their law becomes sovereign. So if you're not sovereign, you can't make law. Now, we've basically already answered this question. Are government corporations sovereign? No, they're not because they act through contracts, therefore they can be sued, and therefore they're not sovereign. But what does the Supreme Court say about this question? In Bank of the United States versus Planters Bank of Georgia, the court ruled that as a member of a corporation, a government never exercises its sovereignty. It acts merely as a corporator and lays down its sovereignty so far as respects the transactions of the corporation. Okay, so there you have it. Corporations are not sovereign. Who is sovereign? Well, if you look up the definition of people, you'll find that people are the repository of sovereignty and the source of government power. And if you look up Perry versus the United States, you'll read that the sovereignty of the United States resides in the people, and Congress cannot invoke the sovereignty of the people to override their will as declared in the Constitution. Also, sovereignty remains with the people by whom and for whom all government exists and acts. See Yickwo versus Huckins. So corporations are not immune. They're not sovereign and cannot make law. Why then would government give up so much power as to act merely as a corporator and lay down its sovereignty? Well, that's because we have constitutional limits. In Article 4, Section 4, the United States shall guarantee to every state in the Union a republican form of government. And in a republican form of government, the powers of sovereignty are vested in the people and are exercised by the people either directly or through representatives chosen by the people. Also, as important as what a republican government is what a republican government is not. And in the Wyoming Constitution, it gives a very good example of that. It says, absolute arbitrary power over the lives, liberty, and property of free men exists nowhere in a republic, not even in the largest majority. And the Supreme Court also has ruled that in Hale versus Henkel, that the individual may stand upon his constitutional rights as a citizen. He owes nothing to the public so long as he does not trespass upon their rights. Therefore, in a republic, there is total and exclusive self-ownership of rights, that is, life, liberty, and property, and it's subject only to the rights of others. A republic guarantees the consent of the governed. The opinion and rulemaking of the majority are advisory, not mandatory, and I quote, even in the largest majority. So the people are sovereigns and the masters of the state. With honest money, the machinery of the state cannot be hyperinflated and cannot be purchased by the money printers to usurp the people. The Constitution is a real problem for tyrants, if you are a tyrant. So why would the government lay down its sovereignty? Well, because by contracting as corporations, government can legally circumvent the Constitution, and that's what they're trying to do. Because when contracting, contracts imply consent, and since the people are presumed to know the law, there is plausible deniability for tyrannical usurpation. We are, in fact, an indispensable part of their constructive fraud. So, what evidence do I have that governments are contracting the people in order to diminish our rights? I like to refer you to 74 U.S. 666, under which the Supreme Court ruled under the Floyd acceptances that our statute books are filled with acts authorizing the making of contracts with the government through its various officers and departments. But in every instance, the person entering into such a contract must look to the statute under which it is made and see for himself that his contract comes within the terms of the law. Now, what does this mean? Let me get this straight here. It says, statute books are acts authorizing the making of contracts with the government. Okay? And it also implies, and it says that the contractor, you have the burden to uphold the law when acting to contract with the government. After all, you're sovereign, and sovereigns decree or at least know the law. These things imply that it is not up to the state to uphold your constitutional rights or even to act constitutionally, as contracts are not extra constitutional, and after all, you are the sovereign, and you have to put the brakes on the state. You have to check the state. Okay, so let's answer the question, are gun laws law? Well, you're the sovereign. You're eminently qualified to answer that question. Let's go back to the basics, the basic elements of law, and in this case, the basic elements of, quote, gun laws. What is the authority of the gun laws? Well, there are corporations, and corporations are not sovereign. And as we proved earlier, if you're not sovereign, you can't make law. What about the subject matter? The subject matter of gun laws are entitlements to possess and carry firearms. If you don't want to exercise that entitlement, then you don't fall under that law. In fact, The gun laws only apply to persons contracting, consenting, or acquiescing to the entitlement, and that is a commercial entitlement of carrying firearms, as we proved in part 1 of this presentation. The enforcement of so-called gun laws is by voluntary compliance. That is to say, if you volunteer, then you must comply. The corollary to that is, if you don't volunteer, then you're not subject to comply. In other words, gun laws are avoidable. And as we know, real laws are not avoidable because no man is above the law. Okay, so gun laws summary. Gun laws are statutes. They are corporate acts authorizing the making of contracts with the government. Gun laws lack sovereign authority. They are limited to a special entitlement in commerce and enforced through voluntary compliance. Therefore, they are avoidable. Your license to carry is a commercial contract made with a corporation having and using the same name as your state. Also, let's summarize some of the basic legal principles presented here. Government maximize control by contracting through corporations. Statutes are acts authorizing the making of contracts with the government. Contracts are extra-constitutional, and you bear the burden of upholding the law or volunteering your compliance. Statutes always convert rights into privileges before relegating people into regulable, liable, and/or taxable persons. Governments use artificial construction, such as terms and state and firearm, and also terms of art, such as the word carry, as discussed in part 1, to convert rights into regulable entitlements. Therefore, you must rebut the presumption. Knowing how your rights are converted into regulable entitlements is the key to lawful subject matter avoidance, jurisdictional challenge, and walking away. Furthermore, the concepts here apply to every act in our statute books, including traffic tickets, parking tickets, road tolls, motor vehicle registration and licensing, building codes and zoning laws, fishing and hunting licenses, alimony and child support, federal income tax, which shall be the subject of future discussion, and of course, dog licenses. Some towns actually require you to get a dog license, if you can believe that, and much, much more. Again, I reiterate my 5,000 Federal Reserve note challenge for anyone who substantially disproves these assertions or presents a critical argument to the contrary. Thank you, and please send critical feedback if you have any. Please share this video because your knowledge is what defends the right to keep and bear arms. And please save our republic. Use honest money. By that, I mean bitcoins and other cryptocurrencies, and also gold and silver. End of part 2. Thank you for watching.